A bellwether trial begins in California as a wave of personal injury lawsuits seek to hold social media companies liable for teen psychological problems and other harms. Meantime, Australia says its new law to bar social media for children under 16 has led to the deactivation of nearly 5 million accounts, while other countries in U.S. states consider implementing their own restrictions.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues on the Journal's opinion pages, columnists Alicia Finley and Kim Strassel. With thousands of lawsuits on the docket against social media companies, the trial now beginning in the Superior Court of Los Angeles County is being viewed as a landmark that could set the tone for the rest. The case involves a young woman known as KGM, now 19 or 20 years old, who blames app usage for her spiral into depression, anxiety, issues over body image. The complaint says this: the more KGM accessed defendants' products, the worse her mental health became. Alicia, start with these mental health claims by KGM. Is there a consensus that social media is harmful in general to teens? And then also, is there enough variation and uncertainty to wonder how KGM is going to prove that her specific problems are the fault of Instagram and whatnot?
Well, I think you get at the rub of the problem, which is that there is a lot of evidence, at least observational evidence, that social media and the introduction of social media to teens in the late 2000s coincided and was correlated with increasing mental health problems among teens, especially young girls. You saw an increase in depression, anxiety levels. Among boys, you saw more kind of internalizing behavior as well. And some of this was documented in Jonathan Haidt's book, The Anxious Generation. Now, the bigger problem for a lawsuit is you need to actually prove a causation, especially on an individual level. And these are not class actions, so they can't just make sweeping claims. And the particular plaintiff in this case, which is a 19-year-old girl, and some of the stories about her mental illness and her descent into kind of body dysmorphia and suicidal ideations are very troubling. And she attributes that to her beginning using various social media platforms, TikTok later on, but Instagram and Facebook and YouTube at a very young age. But this is a point of evidence that the plaintiffs have sought to exclude from the trial, is that she also experienced domestic abuse when she was a child, actually a toddler, and then she actually had to go to therapy because of that. And we know, obviously, that trauma and abuse as a young child can result in mental illness and issues later in life. But you have thousands of different cases, and trying to disentangle the effects of what people are exposed to in their personal life and other events from actual the impacts on social media are extremely difficult and probably impossible to do. Typically in a trial that like this, you would look to kind of randomized controlled trials to see on a population level, like if you expose someone to social media and had a different group that wasn't exposed to social media at all, what the effects would be on, or what the mental health effects would be in those two different groups. But you can't really run that randomized control trial, or none has been run. So you're left to look at observational studies that have many, many confounding problems in terms of influences and what kids are exposed to, at what time or age in life, which makes the plaintiff's argument very difficult to test and to prove.
Some of the evidence that is being introduced in these lawsuits, and not only the one involving KGM, are information from internal documents obtained from these social media companies. So a couple of examples. Here's a CNN report on one of these lawsuits. Snapchat executives once acknowledged that users who have, quote, have the Snapchat addiction have no room for anything else. Snap dominates their life, unquote. This is from another news story. IG referring to Instagram is a drug. A Meta senior researcher is quoted as saying in one internal documentation referenced during a sealed deposition. That employee then said in the deposition that this was meant sarcastically. Meta spokesperson tells Politico that the company says these are cherry-picked quotes. Kim, not a great look for these companies. On the other hand, you still have this causation problem that Alicia is talking about, and the approach here seems to be to treat these social media companies with the way that big tobacco was treated, except that the real research and the link of tobacco to cancer in individual cases is pretty hard to deny, whereas the problem of teens who have a lot going on in their life, including real life episodes of bullying and whatnot in the classroom, in the locker room, it becomes much harder, I think, to figure out what role a specific social media platform played in some kind of mental health problems.
Well, you can also look at it this way. I mean, we know people who smoke, everyone who smokes, there's some sort of physical consequence from it. You can actually look at it, you can measure it. It might not always be lung cancer, but it has to do with cardiovascular activity and a whole host of other ranges of medical and health consequences of smoking tobacco. Whereas when you look at young people who are on social media, there might be some who end up with problems. And it might even be because they overuse or compulsively use social media. But you can also have plenty of examples of kids who use social media a lot and do not have these problems, which means drawing that link is much harder to make. You can't necessarily have a straight line between using social media. We know that individuals, for instance, who have compulsive personalities, might be at higher risk for mental illness. And so they might become more addicted to social media. It might affect them in different ways. We know that, obviously, as Alicia was mentioning, there was domestic abuse in this particular case that we were just talking about. But that gets to the point about parenting. And how parents are engaged and whether or not kids are turning to social media as escapes for things and other problems in their lives. And so, again, I think detangling this is almost an impossible task. Then there's also the legal questions, which we can certainly talk about. Because not only is the causation question difficult, but Section 230 is set up in a way that this gets into the question of whether or not these providers can be held responsible for the content and whether or not it's the content itself that is in fact addictive.
Well, Alicia, that's where I was going next, because that seems like also a really hard thing to untangle. So Section 230 gives internet providers immunity for third-party generated content. And the social sites in this case have argued that that protects them from these claims by KGM. And so just to make up an example, if you're a user of a social media site and you come across some influencer who is posting about dieting and you start intaking that content and it gives you body image issues, the argument of the social sites is that what is causing those psychological harms is the user-generated content. And the judge in this case, I believe, has, for now at least, rejected those arguments, allowed the trial to go forward. But I can only imagine that that is going to be an issue on appeal. And that is why the KGM lawsuit is framed in terms of the design of these sites. So it is arguing that the psychological harms were caused by design features on these platforms like autoplay videos, infinite scroll, and so forth. But to my mind, that is not a very clear-cut example of something that does not fall under Section 230 protections. And if you look around the internet on places that are not social media sites, you can often find stuff like infinite scroll and autoplay videos in places where it is perceived to be a useful feature, so you don't have to keep clicking over to the next page and waiting for the next page load.
Right. So Section 230 prevents these interactive platforms, which would be all these that are being sued, Snap, YouTube, TikTok, and Facebook. And just to back up a little bit, all those platforms are being sued in a variety of cases. TikTok and Snap settled this particular one with a 19-year-old, but they are still defendants in the thousands of other cases. Now, Section 230 prevents all these platforms, at least on its face, from being held liable for the content posted by third parties and other users. And so these plaintiffs couldn't sue the platforms for that, though any kind of content or post that encourages eating disorders or suicidal behavior and such. However, they are trying to end run the law, and it's not just these individual plaintiffs, it's also school districts and state attorneys who have brought other suits that are being heard in federal and state courts. They're trying to end run Section 230 by claiming it is a product liability. They were negligently designed recklessly in a way that has caused these plaintiffs harm. And therefore, it is really the design, not the actual content in itself, that is contributing to these various mental health problems among teens. Now, interestingly enough, the Supreme Court Justice Clarence Thomas actually suggested in a concurring opinion, as an aside, several years ago, that, well, maybe one way to get around Section 230 or limit the power of these big tech companies was through product liability lawsuits. And I think that actually teed up some of these cases that we are now seeing, because they think that they may get a friendly forum if these cases are ultimately appealed to the state or the Supreme Court. Now, to your point about the judge is letting these claims continue and proceed, and plans to instruct the jury, which is going to ultimately decide the liability question, to consider whether Section 230 controls or that these cases are not covered by 230. Now, I think this is a fundamental problem because this is a question of law that should be decided by a judge, not a jury. And I do think that, and I know for a fact from talking to these companies, that they plan to appeal that decision by a judge to leave this question to a jury if these cases go against them.
So there have been examples in the past of where judges have found internet app design features to not be covered by Section 230. One prominent one was a 2021 ruling by the Ninth Circuit U.S. Court of Appeals. It involved this snap filter on Snapchat, a speed filter that allowed users to superimpose the speed that they were going over photos or videos that they capture. I believe this feature has since been removed from that app, but it was a case involving the parents of a couple of boys who were killed. Apparently, they ran off the road at something like 113 miles an hour and hit a tree. And shortly before that, they had been using this snap filter to show how fast they were going. And this is a piece of the ruling from the Ninth Circuit. It says this case presents a clear example of a claim that simply does not rest on third-party content. Went on to say that parents' negligent design claim faults Snap solely for Snapchat's architecture, contending the app's speed filter and reward system work together to encourage users to drive at dangerous speeds. And Kim, I would make a distinction because that ruling kind of makes sense to me. It is if this feature is encouraging people to go out and do dangerous things, not based on any content that they are intaking, then it seems to me that maybe is not covered by Section 230. But I have a hard time seeing how Section 230, really applies, and even how the harms that are alleged by KGM here are really a direct result of pretty common features around the internet, like autoplay videos.
Yeah, I mean, that's the problem here, is that we're talking about lawsuits that are claiming broad social ills from mental health problems that are connected to the use of social media. And most of that is about content. And I think we need to think very, very hard about what it would mean if these lawsuits were successful and we were able to erode Section 230 protections and making these platforms liable for content. Are they going to be liable for every photo out there that makes somebody unhappy when they see it? Are they going to be liable for social bullying, even though they have no ability to control that? It would fundamentally alter this universe. And in my mind, that is the argument for why these issues do not belong in court. Now, one thing that has come about as a result of these lawsuits, but also the increased conversation about this in Washington, and now we have other countries passing laws and states that have been ramping up new provisions against this, is that these companies themselves have finally started to take this more seriously. And I speak here as a mother of children who has been fighting with this technology for years now. I mean, 8-9 years. And when all of this first started coming out, the companies claimed to have provided parental controls, and they were useless and they were impossible to kind of implement. And yes, kids are smart and they know how to get around things, but the focus should have been from the beginning, easing the way for parents to have more control over what their children were doing. They're finally getting more serious about that in the face of new restrictions being put on them. That might be too late. And, these lawsuits, I think, are an increased argument for why Congress and states need to be looking at this more closely. And if there's a decision about social harm, mental health, maybe coming up with a clearer rules of the road that everyone can follow. But right now, this is a kind of wide open field, and it's not surprised that plaintiffs' lawyers are trying to cash in on it.
Alicia, if maybe the best place to handle this is not the courts and individual cases brought by the plaintiffs' bar against individual social media companies, throwing all these claims to juries, which might come out differently on them. Maybe it's legislation. And we've talked in the past about the new law Australia enacted that came into effect in December, banning kids under 16 from social media sites and requiring those tech companies to take reasonable efforts to eliminate those accounts from their platforms. In recent days, Australia has now given an update. It says major social media companies removed access to about 4.7 million accounts identified as belonging to children under 16 in the first half of December. One question we don't know is the denominator. If about 5 million accounts have been removed, do the kids in Australia have 10 million accounts? There has been a lot of concerns about how quickly and easily this restriction would be evaded. On the other hand, here's the quote from Australia's e-safety commissioner. While some kids may find creative ways to stay on social media, it's important to remember that just like other safety laws we have in society, success is measured by reduction in harm and in resetting cultural norms. Speed limits, for instance, are not a failure because some people speed. And notably, a second country now potentially moving to follow Australia's lead here, that is France. The lower house of the French parliament has now passed a law banning under 15-year-olds from social media with the support of President Emmanuel Macron. Macron tweeted this: as of September 1st, our children and adolescents will finally be protected. I will see to it. The bill is now going to the French Senate, but Macron sounding pretty confident that it will pass. Alicia, to my mind, a lot of these laws are still kind of experiments based on this emerging consensus that there are harms that are created, especially by teen, preteen, adolescent use of these platforms unrestricted. In the United States, there's an additional complication in that we have pretty broadly construed the First Amendment protection for the freedom of speech. So many states like Florida that have tried similar things have wound up tied up in court. And we have to wait to see how the Supreme Court and the justices will ultimately come down on these kinds of restrictions. But it's nice, I guess, to see some experimenting, and we'll have to see exactly how all these ID laws work, how the verifications seem to work, how countries and states decide to crack down on this evasion problem. But maybe it's a start.
Well, I think that's right. I think most countries and governments are seeing the bale effects of these social media platforms on adolescents, and I do think in some cases they can be addictive to teens who or have compulsive personalities, or spending, as a result, are spending a large share of their after school hours and even some of their school hours online and scrolling through these feeds and posting and all of that. Now, what these laws are intended to do is to get around this kind of collective action problem where parents are afraid of taking away the phones or restricting their use, because they worry that their kids may then become unpopular, maybe become pariahs, and subject to more social bullying. Now, if everyone's offline, if all teens are banned from using these platforms, then teens don't have to worry as much. And I think you've actually seen some surveys that show that teens, a growing share of teens, believe that social media has a negative influence on their mental health, and would support a broader a ban on their use. However, they don't want to be the only one who isn't on these platforms. Now, to your point about the First Amendment issues, I think that's right. There was a case in 2011 that involved the California ban on minors buying violent video games without, parental approval. And the Supreme Court struck down that law, finding that these video games were protected by the First Amendment. There was a kind of divided opinions among the conservatives on the court. Justice Antonin Scalia, interestingly, was among the majority and said, well, this really isn't, the video games really aren't any different than Brother Grimm fairy tales, and therefore deserves equal protection. I think that there were some conservatives also in a concurrence, based on the fact that they believe the definition of violent was overly vague, but also suggested that, well, the majority in that case overreached, and that the government and states do have a compelling interest in protecting minors, and were worried that the court had overreached in its opinion, and suggested that they would be open to other kinds of state laws if they were more precise. And you've seen in the lower courts have cited this 2011 decision to block some state laws. But in other cases, they've said, well, that the 2011 law or 2011 Supreme Court really isn't necessarily apropos to the social media context. And so I think what you're going to ultimately see as more of these state laws come under challenge and they percolate in the lower courts, and it probably will get up to the Supreme Court, and will give the Supreme Court an opportunity to revisit this 2011 decision, or at least narrow it potentially to the social media realm.
Kim, what are some of the other ways that states are trying to tackle this problem?
So there's some really fascinating stuff out there. I mean, just right now, Virginia just had a law that went into effect on January 1st, which is requiring social media companies to limit kids' usage to just 1 hour every day. We'll see how well that goes. They're going to require social media companies to verify the ages of account holders so that this applies to those under 16. Kids, again, are pretty clever. But, we now have in Massachusetts, they're having a conversation about an entire school phone ban, which is inching toward approval. We're seeing that in other states as well, too. We've had, 8 states have enacted laws that ban minors from social media or require some sort of parental consent. California and New York have created these bans on, quote, addictive algorithms for minors, which, gets a little bit into the features, again, of the technology that is being used. Connecticut and Arkansas are moving to do the same things. We have some states that are taking softer, different approaches. North Carolina, for instance, is now requiring social media health courses for students to try to raise awareness about some of the problems of overuse. So there's a lot of innovation and thought going into this out there. We're still creeping our way forward. We don't know exactly what's going to work best and the limits of how much you can impose without kids just getting around it. But it's the good news is that this is finally broken into the public space and that people are recognizing that there's a problem. The question that really needs to be dealt with is where's a proper place to deal with that? I would argue it is in legislation and in the home. These lawsuits going after the companies themselves mostly will enrich a lot of greedy lawyers, but probably won't accomplish much else.
Thank you, Kim and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.